All right. Well, the trial of that could really alter the real estate industry is now underway. So there's a ton of stuff for us to unpack on today's episode. We're going to talk about the first day of the trial. We'll talk about what happened yesterday, day 2 of the trial, and we'll try to keep you guys up to speed with this trial as in real time as much as we possibly can because of the massive implications that it can have on our industry. But first, I want to talk about a report that was released by an investment banking firm, Keefe, Burnett, and Woods, whose forecasting commissions could decline by at least 30% as a result of ongoing threats to the real estate industry. So let me read to you what they said in this report, and then we'll unpack this. So here's what they said. The annual pool of real estate commissions could drop as much as 60% if the courts hearing class action lawsuit ban cooperating compensation, according to this new report. So the report said it's very likely that cooperative compensation, whereby listing agents share commissions paid by homeowners with buyer's agents, will be banned in the future. It puts the odds of a ban on cooperating compensation at 50% and 75% likelihood in another case that's going to go in trial later this year. They say, I quote, "We believe disruption to the industry's commission structure is all but guaranteed. While this disruption should improve consumer transparency around commissions, which economic theory suggests should reduce housing friction cost, the key question is whether this disruption actually changes anything in practice." So they go on to say, he says, I know we have some aggressive numbers in the report. Whether those numbers have a 50% probability or a 5% probability, they're still meaningful enough and it deserves people's attentions. Unlike the most likely scenarios, the firm said it expects agent count to decline as much as 80%, with members of National Association of Realtors falling from about 1.6 million realtors to between, listen to this, 300,000 to 600,000 agents. KBW, which is the firm, reached that assumption based on the possible commissions of around 2 to 4% per transaction if the listing agent commissions are completely separated from buyer agent compensation. What it shows us is that theoretically, the U.S. should only have about 500,000 agents. NAR didn't respond. The timeline for the changes is unclear and will depend on how things play out in court. No matter who wins the trial, the losing party will almost certainly appeal, so it might take years before a final decision is made. Our sense is that institutional investors are informed on this topic. Investors and market participants that do spend time on this initially come up with perhaps a bit overly dismissive of the impacts that it could have. So let's just talk. You know what? Hold on, because there's some really, really good stuff too that he goes on to say about buyer agent commissions. So companies that rely heavily on commissions, then one agent for revenue, like Anywhere, Compass, Douglas Elliman, Remax, they have more risk than those with a franchise model. Companies that rely on generating buyer leads would also heavily be impacted, specifically Realtor.com and Zillow. So let's talk about this, because there's two things that stood out to me. One was buyer agents being banned, and the other is if the court rules that it's no longer required to offer a buyer agent compensation, will it still happen in practice? So we have with us today, we've got Ben from the team, we've got Dominic from the team. We also have an attorney with us to help us kind of interpret some of these reports. So Dominic, let me go to you first and see what stood out from this article.
Well, thanks, Brandon. Thanks for having us here this morning. Yeah, there's an awful lot to unpack in that report from Keefe, Burnett, and Woods. They are obviously looking at this from the most extreme set of circumstances because, well, they're in the risk aversion business as investment bankers. But if we end up being reduced to 300,000 to 600,000 agents, and commissions are in fact cut by 50 or 60%, what we're looking at is a serious redistribution of wealth. I mean, that money's going to go somewhere, right? It just won't be going to agents anymore. It'll end up being spread out over real estate attorneys. Ultimately, sellers will end up keeping a little bit more of that. And agents as a whole are going to have to work. The remaining agents will have to work a lot harder and produce more volume to maintain their current levels of income.
Yeah. And they talked about what that in the article. And I see it just a bit differently, like you and I seem to be recently, because I think that what it said was that market share would just be more evenly distributed through the agents that are in the business. And thus those agents, it would just be a professionals market, that they said that the vast majority of licensees anyways are the part-timer weekend warriors, and the industry would just be left over with the full-time agents that are career agents, and that those agents would just pick up a lot more market share, and specifically all be listing agents. So Ben, what were your thoughts on that?
Yeah, I was kind of curious around what that number is, if you knew it off the top of your head, of agents that are selling, 5, 6, 7 homes plus a year, if that's really what we'd be losing, which, it almost appears to be worse than it really is.
Yeah.
A lot of people hold their license and don't do a lot with it anyway.
Yeah. Yeah. I mean, my thing is that, and the last episode we made, I mean, people in the comments were so, I don't know if the right word was offended or upset that I was, it seemed like I was attacking the buyer's agent. And it wasn't that I was attacking the buyer's agent. I'm trying to speak from a place, or a world rather, if buyer agents commissions are banned.
That's right.
Not if it's
there.
It's already happened. That's what I'm trying to wrap my head around. That's what I'm trying to communicate and speak from. And so it's no longer an argument of, is it good? Is it bad? I'm not debating that. I'm debating, what does this world look like when there is no buyer agent commissions? It's illegal, sort of like kickbacks. They talked about this a lot in the trial, that buyer agent commissions could be looked at as a violation of like a referral fee or a kickback. Go ahead, Bill, what were you going to say?
Well, when you said it's already happened, has there been places that it's already been banned?
No. I am trying to look through the lens if it were to happen.
Oh, okay.
So, because there's a lot of people that say, "Oh, I love the buyer's agent." No, you're wrong, Brandon. There's a lot of value with buyer's agents. They're arguing the value of the buyer's agent. It's the wrong debate, because if the U.S., if there's a law that bans buyer agent commissions, the same way the CFPB has banned kickbacks, that's the lens I'm looking through. It's not whether you think buyer's agents are valuable or not. I'm talking under the context of the U.S. puts a law in place that says it is illegal for listing agents to pay buyer's agents to bring a buyer to the home. That's the context that I'm operating from.
Yeah, I get it. I mean, it seems, I guess maybe I'm stuck in the old way of looking at it, but to me, it seems far-fetched that there would be a law against it, only because, we have the freedom to contract, right? You can contract with anybody to do anything. And so it seems if a buyer wants to pay, you're saying that the commissions would be banned from the other side.
Yeah, that if you listed a house like it is today, right? And that's what this whole case is about. I mean, it's a $4 trillion lawsuit that essentially would, it would change real estate forever.
They'd all have to be paid by the buyer. All the buyer's agents would be paid by the buyer, yeah.
Yeah, if the buyers chose to do that.
Yeah, probably a flat fee type of model would arise out of that. I'll be your agent for $1,000, $1,500, $2,500, whatever it is.
Yeah.
That would be my guess.
Yeah. Well, I think, again, not to rehash. So anyway, I think that the interesting thing is what this investment banking firm is coming out to look at is what we've been talking about for a long time. And there's a lot of people who actually agree. I believe it was the CEO of Coldwell Banker who said the industry is due for a cleansing. We have way too many licensees per transactions. And so, yeah, go ahead, Dom.
Well, listen, finish your thought there. I've got some thoughts on this, as you might imagine. But go ahead.
So I think that even people that are on the other side of this suit can see that the industry is due for some updates. One of those being, again, whatever you want to call it, there's just too many people in the industry for how many pieces of the pie there are available. And so regardless of what happens, I think a lot of people in the industry is saying we're due for that. We're due for this industry to kind of go through some massive changes, whether that be commissions, whether that be what it takes to get into the industry, whether that be what it takes to stay in the industry. And so, yeah, if it's 30, 40, 50%, I mean, we're already seeing agents leave the market in mass droves already. And nothing has even happened as a result of this suit. So, yeah, Dominic, what are your thoughts on that?
Well, I'll tell you, you kind of touched on it a little bit with the statement you said from Coldwell Banker's CEO, that basically what he's saying is that perhaps the industry is bloated. And that's what the crux of this lawsuit is, Brandon. I just came to me last night as I was researching this. That's what this is all about. This really isn't about a real, true violation of the Sherman antitrust law. And I'll tell you, let me explain. This professional witness that's going to testify on behalf of the plaintiffs, Dr. Craig T. Shulman, this is his specialty, right? He goes after these antitrust suits, and he says exactly what this is about. He said he will testify that commission rates have for many years remained uniform and steady at about 6%, which does not make economic sense and could only occur in a market with anti-competitive restraints. It also doesn't make economic sense that buyer agent commissions do not vary based on competitive forces or market conditions, including agent experience, quality, seasonal trends, or competition in the market. Now, he goes on to say that other commission-based industries, due to increases in efficiency because of the internet, have been slashed, for example, stockbrokers. So what this is people outside the industry saying, whoa, real estate agents just make too much money. This isn't fair. That's what this is really all about. They're going to have a hard time proving that there's a conspiracy here. This is just home prices are not 80,000 anymore. They're 500,000, and 3% of that is just more than people on the outside can bear to see. And so we're going to see a compression of the market, and we're going to see listing agents, the 300,000 agents that are left in the business, they're going to have to work a lot harder, I promise you, to make the same amount of money. And we can unpack that in a second, but that is going to be true. That's immutably true. You're not going to be able to just keep cruising. The 300 agents that are left aren't just going to get more market share and have it the way we have it now. It's going to be more difficult. More work is going to be involved, and there'll be more expense involved in maintaining this business model.
Great point.
You just nailed it. That was awesome.
Yeah. No, I mean, it's a really good point, Dom. I mean, I think that, yeah, there's a lot of people that are going to testify on behalf of the plaintiffs that are arguing exactly what you just said, is that enough is enough. This industry of real estate and these commissions, it's due for an awakening, just like they've done to the travel agent, just like they've done to, LegalZoom, just like they've done to all these industries. It's like, this is finally the thing that we're going to hang our hat on to slash this industry. Because to your point, in the same article, they said, and this is what I was arguing a week ago with you guys, is that I think the number now is 87% of buyers find their house without an agent, right? And so the argument that they're going to make is that, look, jury, this needs to be slashed. And that's just one part of their argument. We're going to get into opening arguments in just a second. But that was one of the major things, to your point. And I think you're right. I think that the underlining kind of fight behind this, why so many people, why the attorneys for the plaintiffs have so many resources helping them in this case is because there's a lot of people that are vested into seeing what you said happen. So, yeah, go ahead, Bill.
Do you know who's funding the plaintiffs?
No. That's a great question, though. That's a really, really good thing to probably find out.
Well, I mean, you said that they're so well funded. I would agree with you. I mean, based on the nature of the lawsuit, but it would be interesting to know who's writing them checks.
Yeah. So let's get into day one, right? So this trial, that's set for 3 weeks, started on Monday. And I want to get into some of like the initial arguments each side of the case had. And let's start off with the plaintiffs. All right. So this is like the most important piece. So there's a lot to this. So let me get through this and then we'll talk about the plaintiffs first. So in their trial brief, the home seller plaintiffs allege that NAR's rule, which they call the mandatory offer of compensation, is a market shaping and distorting rule that stifles innovation and competition. So this is in quote, the rule requires every home seller to offer payment to the broker representing their adversary. This is what Dominic was saying, the buyer, even though the buyer's broker is retained by and owes a fiduciary obligation to the buyer, who may be told falsely that their services of buyer broker are quote unquote free. The current setup where home sellers pay buyer brokers in order to fulfill their fiduciary duty to the buyer client must actively work against the seller's interest by negotiating for a lower home sales price. This defies basic economic common sense, was the attorney's opening argument. They went on to say, the rule also requires that the compensation offered by the same for every buyer broker in the MLS, regardless of their experience, regardless of their quality or service provided. Until recently, that compensation offer was viewable by buyer brokers and their agents, but not to their buyer clients. The mandatory NAR rule has severed the decision to retain a buyer's broker, which is done by a potential home buyer, for the negotiation of the price to be paid by the buyer broker, which is set in the listing agreement between home seller and listing agent. This artificial market structure created by the defendants deters price-cutting competition and innovation, resulting in inflated commissions. Each of the defendants embraces, adopts, and enforces the mandatory rules, among other things, requiring their franchisees, subsidiaries, brokers, and agents to comply with this rule. The corporate defendants compel compliance in multiple ways, including by requiring their franchisees, subsidiaries, brokers, and agents to become members of NAR, writing the NAR rules into their own corporate documents, broker handbooks, and requiring that their franchisees, subsidiaries, brokers, and agents become members of the participants' rules. So this is where they talked about Dr. Schulman that Dominic just brought up, which was really good. Specifically, Dr. Schulman determined that in the subject MLSs, the offered commission rates are highly uniform, and the offered rates are almost always the rate that is paid. He will testify that the commission rates for many years have remained uniform and steady, about 6%. This is what Dominic said. And he'll argue that it makes no economic sense whatsoever. So to date, the defendants have siphoned off more than $1.3 billion in economic, irrational, and unlawful commissions of the class. Because of this case, the damages may add up to about $4 billion. So that was the opening argument, kind of recap of the plaintiff's attorney. So let's talk about that, and then we'll talk about how the attorneys responded to that and their opening arguments for the defendants. So, Ben, what was your biggest takeaways from that?
They're coming in swinging, that's for sure. And as we've talked in the past, it's like, this just as getting as far as it has been just eye-opening of what's possible, right? So if we look at this argument of coming in here, wiping out this completely, all of those damages, I mean, Dominic hit it earlier, but I'll let you guys tee it up, but yeah, I have a couple things to say, but I'll let you guys start it off.
Yeah, no worries. So Dom, your thoughts on the opening days kind of arguments from their attorney. What are your thoughts on it?
Yeah, I mean, they've been projecting for some time now that this is what their argument is going to be, and that what they're maintaining here is that NAR in their policy has created this situation where the seller is being forced to pay the buyer's agent out of their own fees, and they're paying for somebody to compete against them. But we know, I don't want to get into the legal aspects of this. I'm not sure how, we can go into the weeds, right? Because we all know that you don't have to participate in this system. This is the part that I just can't come to terms with. You are free to go and sell your house anywhere else you please outside of the MLS without any interaction with NAR. People you choose to use that system because it's the best database and it's the best network of agents and buyers that are willing to pay the highest possible price for your home. There's no, I don't know what to say. I want to keep coming back to that, Brandon, but the opening statements are what we expected them to be.
Yeah, absolutely. And you nailed it. I mean, because some of the stuff you're bringing up, Dominic, is exactly what the attorneys for the defendants, that's their opening argument, which we're going to get into that in just 1 second, because I'm with you 100%. There were some specific things that the attorney for the defendants, NAR in particular, bring up that are going to be really difficult for the plaintiff's attorney to prove. One is the conspiracy, that these guys all came together and they formed this huge conspiracy to have this money-making scheme. Number one, that's going to be really difficult. And then number two, to your point, which we're going to get into exactly what he said in a second, all these sellers signed up for this. All these sellers decided to do this. And so, Bill, anything to add there? Because I want to
money, right?
Go ahead.
And the path of money, right? The seller is paying the listing agent, and we'll get into all this, and then it gets distributed to the buyer's agent. They're not paying them directly.
That's right. All right.
You guys are, from my perspective too, the contract is between the listing agent and the seller, right? And they're agreeing to pay 6% to the listing agent. The listing agent agrees to split it with the buyer's agent. So I don't know.
It's going to be tough. That's exactly right. That's
and by the way, that's in the contract. When it says in the contract between the agent and the seller exactly how much the agent is going to offer to the cooperating buyer's agent. None of this is a secret. And the fact that NAR has had this policy has been transparent and in their documents, in their public documents for 25 years. It's never been a secret. There's no conspiracy. How can this be a conspiracy if it's been public and open for anybody to see?
That's right.
My understanding of, with the word conspiracy, that's an element of the charge, right? An element of the tort, I should say.
Correct.
So the problem with that is, and even when you look at it from a criminal perspective, the conspiracy to commit murder is an actual separate charge than the actual murder. So if you conspire with one other person and say, hey, we should go do this, you're guilty of conspiracy, right? So I think that translates to the civil side in this lawsuit too, where there's just an informal conversation could constitute a conspiracy.
Well, that's interesting. I mean, they brought that up in day two's arguments, which we'll talk about in just a second. All right, so then NAR's attorney comes up, and this was their opening kind of statements. So NAR argued it does not receive, study, or track commissions, set commission amounts, determine who receives commissions, or decide how commissions are paid. The nearly 1.6 million member trade group also noted that its code of ethics specifically states that realtors are not obligated to share commissions, fees, or otherwise compensate any other brokers. NAR's model rules also do not require sellers to do anything and do not prevent sellers from doing anything. All 500 or so MLSs owned by realtor associations nationwide must follow NAR's mandatory model rules. The association's policy statement 7.23, also known as the participation rule, is the primary rule being challenged in the case. Now, according to the filing properly with the multiple listing service, participants make a blanket unilateral offer of compensation to other MLS participants and shall therefore specify on each listing filed with the service by the listing broker to MLS participants. This is necessary because cooperating participants have the right to know what their compensation will be prior to commencing their efforts. Makes total sense to me. The listing broker retains the right to determine the amount of compensation offered to subagents. The listing broker retains the rights. Compensation offered to subagents, buyer's agents, and to brokers acting in other agency or non-agency capacities. NAR's brief asserts that 3 facts about this rule are undisputed. 1, it imposes no obligations on sellers. Number 2, it imposes no particular amount the agent representing the seller must offer to pay the agents helping her sell the home. And 3, it explains that its purpose is to make sure agents know how much they will be paid before they do any work. This means that sellers are free to choose their agents, how much they pay those agents, and how those agents are paid. NAR's trial brief does not mention the part of its MLS handbook that it says multiple listing services shall not publish listings that do not include an offer of compensation. NAR has consistently said in legal filings and public statements that the participation rule stipulates that listing brokers can offer buyer brokers as little as 1 cent or $1 in order to list the property in the MLS. The brief goes on to say that neither NAR's rules or its code of ethics prevent sellers from negotiating commissions with their agents or prevent the agents from negotiating with other agents. Moreover, NAR argued that agents affiliated with the defendants would make offers of compensation through the MLS without NAR's model rules, where there is no evidence that the offer of compensation model rule was ever reinforced. There is no direct evidence that the defendants argue with each other to enforce the NAR's rules. Plaintiffs' conspiracy allegations boil down to an argument that trade associations are walking conspiracies, which courts have routinely rejected. The briefs suggest that the plaintiffs will claim that offers of compensation have been clustered as certain levels, but says that the plaintiffs ignore the fact that there is competition, including commission decreasing, offers of different compensation rates, and negotiations of commissions between listing agents and sellers. Lastly, NAR said it would argue that the plaintiffs don't have standing to sue for damages because under federal and Missouri antitrust law, only direct purchasers, Bill, this is what you were saying, can be allowed to sue, and the plaintiffs have not brought anything from NAR or the other defendants. When a listing agent makes an offer to pay a cooperating agent, the listing agent is the direct purchaser of the cooperating agent services, not plaintiffs or the other sellers. So interesting. That part I want to talk to you guys about. And according to those rules and listing agreements, plaintiffs did not directly pay cooperating agents. They did not pay NAR or any other defendants. Sellers only directly paid their listing agent and only directly received services from their agent. Therefore, at best, plaintiffs might claim that they paid their listing agents who are not a party of this case, who only them paid defendants. But such as an indirect claim is prohibited by the Supreme Court case law. That's a pretty good blowback from the attorney for NAR. I mean, Dom, let's go to you first, and then Bill, I want to get your thoughts on how you think those arguments shaped up, or how this attorney did, rather. Go ahead, Dom.
I mean, from a legal, purely, obviously, I'm not an attorney. Bill will have to weigh in on this, but that would seem to be anyway a cruise missile launched from a legal standpoint. The fact it's true. It's true. What is the difference between, as a listing agent, if you're being paid 6% to sell a home, if you spend 3% of that money on a billboard on the highway to attract buyers versus paying that 3% to another agent to go find you a buyer? What's the difference?
Great point. I mean,
yeah, I love that argument.
I think this attorney did a hell of a job, because you guys, we've been covering this story for months and months and months and months and months. And, we've all vividly said, I don't know how the attorney for the plaintiffs is going to win that argument. It's like every single one of the people in the class action, every single one had the opportunity to hire any agent that they wanted. They chose to hire an agent who they negotiated the commission with. They agreed to pay that commission. They signed a contract paying that commission. They signed a contract saying, hey, I can use this commission however I want, including offering compensation to another agent. Another agent brought the buyer who you accepted the offer from. You met the buyer and the agent at the closing table. You got the money. You took the money. You cashed the money. It's like, it's just going to be so difficult. So difficult. Bill, what are your thoughts on that?
Well, I mean, I agree with what you guys have just said. It's hard for me to agree with the plaintiff on any of this stuff. I don't know if I'm biased because I'm in this business or what, but I agree with the defense on pretty much everything based on what you just read.
Yeah, I mean, it's pretty good. It's a pretty good argument. Ben, you got any thoughts on that?
Yeah, I mean, the fact that everything we just laid out of, it's so transparent to everybody, except the buyer. I think what is interesting, though, is that they did, right before the leading into this trial, they changed the rule from $1 or it was a cent or whatever, meaning that you had to give something, to zero, and how leading into that was a big admission of guilt. So it'll be interesting to see where they take that. But yeah, I mean, nobody followed it, even though it was an option, right? Everybody kind of followed and put it out there of 3%, 2.5%, whatever.
Yeah, and that
Which were the companies that settled already? Was it Reality?
Remax, and the company that used to be Reality, now known as Anywhere. Both of them have already settled.
Was there any information out there about the result of that settlement? Meaning, did they agree to change a practice?
Yes.
Did they sent stuff out to their franchisees and things like that?
Yes, all of which has occurred. And so the biggest thing that they agreed to do is not require their agent to offer any buyer agent commission. And so, I think
so they're not required, but is it still being practiced every day in the same way?
Yeah.
On all those franchisees?
That's I think the argument, right? It's like, I think that's what NAR's arguing, is for this entire time, the only thing that we required was if you're going to use the MLS, and if you're going to offer buyer's agent to bring a buyer, that you must disclose how much that agent's going to get paid. Right. Full transparency. And so that was the rule. And so again, there's a difference between like banning something and then what's practical application. And I think what you're alluding to is even if somehow this trial goes in favor of the plaintiffs, it's still like, okay, well, you're not required to do anything. That's different than what most people will still choose to do, right?
Right.
And so I think that'll be different.
This is a practice that's evolved over time. It's not like 2 years ago they said, okay, this is how we're going to do it. Here's the new standard, blah, blah, blah. So that being said, it seems to me that when things evolve over time, there's a reason for it, right? Like, this is the way business is practiced because this is what's worked for so long. And when you try to fight those naturally occurring forces, it seems like it will revert back to that if there's not enough supervision. I don't know if I'm getting too convoluted.
Yeah, no, Bill, you hit the nail on the head. Back in the 1980s, there were lawsuits by buyers against sellers because buyers were going unrepresented, and there were less than scrupulous practices going on because sellers had representation and buyers largely had none. And so these lawsuits ultimately ended up allowing buyers agent participation in the process. It's been that way for 40 years.
Right.
And so, yeah, you're right. It's going to be difficult to decouple that, because why wouldn't we just end up back in the same place again?
Yeah. Right. Well, and the argument that
can you guys imagine a world without realtors? I mean, people trying to buy and sell, like it's hard enough to get them to the closing table with two professionals.
Yeah.
I would love to see the Wild West come back and just laugh about it. Watch everybody suing each other and just going nuts.
Well, so what you guys are talking about in day two, the attorney for the plaintiffs brought that up. They're going to make the case for a market without buyer's agents. Just they specifically said, just like Australia, specifically, we're going to make the case for why that is better. And so in day two, just a couple of quick notes on that that we can talk about. This is what the attorney said, the plaintiff's attorney said, and I quote, "I'm going to prove to you that defendants joined with the National Association of Realtors in a conspiracy to follow and enforce rules increasing, inflating, and stabilizing prices paid when you go to sell your house, and return the housing market to fair competition." So, and then he goes on to talk about, part of that argument is going to be what it looks like in Australia, what that market looks like. And this is where he brings up, and I'm sorry, I said something incorrect at the beginning of the video. It's 72% of buyers find their home right now without using an agent. That was one of the stats he brought up in day two's arguments on why the buyer agent commissions are inflated.
Where did they come up with that stat? That seems really high.
I don't disagree. I would make the argument that it would
the internet, basically. Like they find it on the internet, they request a showing, and they buy it.
Yeah, that's the argument I made last week that everyone got all up in arms about. But like, I would venture to say, Bill, it's higher.
Think so?
Well, yeah. Think about this. Nowadays, how often is it that the buyer reaches out to their agent to say, "Hey, this new house just hit the market. Can you get us in there tonight?" Versus the agent saying, "Bill, I just found this awesome house. You guys are going to love it."
Right. No, you're 100% agree with you on that. But I mean, most of those calls come from the drip campaign from the MLS email that they're doing. At least that's my experience here.
Or Zillow.
Yeah, or Zillow. Sure.
I mean, here's the thing: the buyers have themselves up on their own alert on Zillow. They know about properties hitting the market before the agent does. Even if they're set up in an auto alert in the MLS, the buyer knows in most cases when houses hit the market before the agent even knows. So, I don't want to get back into that whole thing, but like, I don't see how agents would argue that fact. Like, I had some people in the comments of the last video say, no, I'm always bringing these properties to my clients and they don't even know. I'm like, you're talking about the exception. 99% of the time, your buyer sends you a text to say, "Oh, this looks amazing.
I like this one.
I like this one. Yeah. Can we get into it?" I mean, I don't know how you would even argue against that.
Yeah, no, you're right.
Okay. The only other piece I want to add from day two that NAR's attorney brought up again, and I think the attorney's doing a good job. So the attorney, his last name is Glass, Ethan Glass. He said, "The jury is going to be responsible for not falling prey to the plaintiff's shell game. Grandma used to say, 'Follow the P,'" he said. "The P in this case is the mandatory offer of compensation rule. We will show that NAR does not set commissions. NAR doesn't even mention commissions. The rule has and I cut that off, but his whole point was the argument here, it's like the mirage, right? It's like they're going to try to prove that like they said it, right? And he's like, just be aware of that." He said, also noted that the plaintiff's claims are based on conjecture and records of documentation are needed to prove that a conspiracy was taking place. This is amazing. Watch this. He said, "The plaintiffs signed a contract, so they knew exactly what to expect when they agreed to hire the agent to sell their home." It's so good. Like, that's going to be very tough to prove otherwise. That whatever 300,000 homeowners had no idea how much they were paying the agent, had no idea that there was another agent involved. It's like it's going to be very difficult to argue, I think.
I agree. It's a tough one.
So they want to pin Keller Williams and these other brokers of being a part of this conspiracy. Like, tell me about that.
Well, that's the whole thing, is that like he's going back to say that these companies are all in cahoots together, that that them and NAR had this conspiracy of inflating these costs, and it was essentially a money making endeavor. And so the arguments that they're making, their attorneys are making, the Keller Williams attorney and the others are saying, we have nothing to do with NAR's policies and what they come up with. Zero. Some of the attorneys brought up the case. They brought up some training documents from Keller Williams as a part of their evidence to say, well, look here, in your scripts, you're training your agents to communicate this way. And so much so, part of your scripts were teaching your agents to not show properties that offer less than 3% commission. You know, and how to communicate that to a seller, which they're saying this is proof that agents are inflating commissions because they're scaring sellers into paying more commission, leading the seller to believe that if you don't offer this buyer agent commission, there's a chance that you're going to not sell your house or sell it for a lot less money. Dominic, your thoughts on that? I know you do.
Yeah, I mean, you can make the argument. So many different ways here. A good example would be, let's look at another industry. How about the landscaping industry? Right, when you hire a landscaper to come and mow your lawn and edge and take care of the shrubs, you negotiate whatever fee you want with that guy, and on the other side of it, he is negotiating the highest possible fee he can get for that. You don't have to hire him. You can hire any other landscaper that comes along and offers to do it for less or offers to do more for the same amount of money. This is
not only that, but add a layer to that, Dominic. The landscaper that's negotiating the sale of the fee, right? He then pays a laborer a much smaller amount, but it's not the homeowner's worry how much that laborer is getting paid.
Great point.
Fabulous. Yeah.
That's what happens in real estate.
Bill, look at you. See, I knew you'd drop some value. That's why I brought the attorney on.
Bill?
No, you cannot go home yet. We're still paying you. Just send me a bill after this.
Right.
So Bill just hit it. Well, great. First off, Dominic, you probably should have been an attorney. I mean, truly.
I was thinking that too.
I mean, you're so well articulated, and the way your brain thinks, it's really valuable. But it's a great analogy. It's homeowners negotiating with the landscaper, and there's an agreement between those two parties. And then what Bill said is exactly what happens in real estate. Is you agree to pay this landscaper $3,000 to put these rocks in your backyard to do this, that, or the other thing. It's not of your concern where the $3,000, how he uses the $3,000 to do the job. It's you agree to pay $3,000 for this outcome. And then to Bill's point, I go hire 3 people on my team who I'm going to pay an hourly wage to help me do the work. And then the homeowner coming back and suing him saying, wait a minute, I didn't
you were going to make money off this.
Well, and it's like, wait a minute, I didn't agree to have people work for you to do this. And it's like, I don't even, it would just.
You're paying them $10 an hour. You should be paying them $5 an hour.
Or I didn't agree to pay them anything. Right. You agreed to pay me $3,000 and I'm doing what it is I need to do to get the job done. No one would ever argue that.
So there's a concept called privity of contract. The homeowner doesn't have privity of contract with the laborer. There's nothing there.
Wow.
There's no connection.
What about the fact of a lot of agents go in, they get 6%, they split it, they pay the buyer's agent 3%, right? And a lot of times they get whittled down and they take it for 5 or 4.5, right? And then what they do is they say, great, well, I'm still going to get paid my fair share. I'm going to take 2.5, and now I'm going to put it on the market for 2.5.
Mm-hmm.
And the seller might, suffer from that because it's at 2.5 and everybody else is listed at 3 because the listing agent didn't put it out there for what's more consistently across the market.
Yeah. I mean, well, that's highly debatable because, I made, nowadays, just based on what I just said, I don't know that that's a issue. That's, I think that is what
they're trying to argue.
Yeah. The plaintiff's attorney is arguing that exact point,
Yeah.
And I think that the point that I made a couple weeks ago that Dominic did not agree with is based on buyers finding their own properties anyway. I don't even think that would hurt the sale of the home, quite frankly. I know, Dominic, you and I disagree with that, but if I were to list a property and not offer a buyer agent commission anything, again, I'm not arguing that the buyer's agent's not valuable. People got so mad about that. I'm talking about in a world, if the U.S. judicial system said it is illegal to pay a buyer agent commission. I'm talking about that. So under that context, I believe that if you were to list a property and follow the law of not offering a buyer agent commission, that house, that you'd be able to sell that house just fine because it's going to get syndicated to the same people, the buyer, and you would just handle the conversation with the buyer directly.
There's no argument there. If buyer's agents are banned and buyer's agent commissions are banned, real estate would have to continue transacting in some way. And you're 100% right about that. If there's any middle ground at all where a buyer's agent can still be paid some way through the proceeds of the sale, then that muddies the waters. Because they just had a lawsuit just ended. REX versus Zillow just settled in August over this very matter. They were claiming that Zillow was hiding listings that were offering a lower buyer's agent commission, and therefore those homes were not selling at as high a rate. They weren't getting as much exposure, and that may or may not be true. But a judge said that no, that's not the case. These listings get exactly the same exposure, and the fact that they're not getting as much activity, well, we can just come to our own conclusion about that. It's because they're not offering the same amount to the buyer's agent.
That's interesting.
Now,
was that a judge's decision or was it a jury trial or what happened there?
I don't know. It was a big antitrust suit that just settled in August. I don't know if it was a judge's decision or not, Bill.
It was a settlement? So they
no, it was thrown out.
Oh, good.
Yep.
It was
completely thrown out. It lasted for a couple of years, but it's thrown out. So
yeah.
But to your point, Brandon, in a world where buyer's agents are just persona non grata, you can't be paid by the seller. Of course, because you can have a contract with anybody at any time, as Bill said, somebody could still choose to enlist the services of a buyer's agent if they wanted. But if they're banned, if the practice of the seller paying a buyer's agent commission is banned, well, the world's going to look a little bit different, and it will look more like the Australian model. I know we're coming up on time, but there's a bunch of problems in this country that are potentially different from what's going on in Australia if we go to that model. It's a huge can of worms.
Yeah, well, yeah, and we'll get into that. I'll just leave this, kind of what Ben was saying. I would love to know, how many, I wonder if there's people inside of the class action where there wasn't a buyer's agent, where the seller hired Bob, the agent, paid them 6%, and that agent sold the house. Why is that? That's got to be brought up in the suit, because it's like, well, seller, you didn't care in that instance. What's the issue? You paid 6% to both people. Just like going back to the landscaper, whether I'm putting the rocks out or I hired 3 people to put the rocks out, what is it to you? You're paying the same amount and you're getting the job that you hired me to do done at the same price that you agreed to pay.